So good evening, everyone, and welcome to tonight's Dominate Law Expert Panel. We are a community built for legal professionals who want to lead their practices with clarity, confidence, and competitive edge. Tonight's conversation, family law in 2026. New risks, new clients, new opportunities, gets into the issues that are reshaping family law practice right now. Changing client expectations, evolving family structures, financial complexity, and of course, the legal risks that are harder to see coming. I'm your host for this session, Don Adeesha, and alongside two extraordinary practitioners, we are going to give you the practical blueprint for navigating what is ahead. By the end of the hour, you will have clarity on the risks that demand your attention in 2026 and the strategic moves that'll set your firm apart. Now, a few quick housekeeping notes to help you get the most of this hour. First, yes, we are recording and you will receive a replay link after the event in your email so that you can rewatch and share with your partners. However, don't let that make you passive because the real value is happening right here, right now, live. To make the best use of your time, engage with us. Use the Q&A button at the bottom of your screen for specific questions you want me to ask the panelists, and use the chat to share your thoughts with your colleagues here. I have my eyes on both the feeds. I will do my best to weave your questions into the conversation as we go along, or else we will tackle them during the dedicated Q&A session for you more closer to the middle of the event. So we'd like to give a massive thank you to our platinum sponsor and growth partner, Echo Marketing, founded by Naren Arulraja, the very same founder of Dominate Law. And for nearly 20 years, Equa has helped attorneys across the globe stop being the best kept secret, and they believe that great care deserves great visibility. Now, before we dive in, here's a quick tip from our team at Equa. When families in your area are searching for divorce attorneys or a custody lawyer or someone to protect them through the hardest moments in their lives, does your firm actually show up? Or are they finding the firm down the street instead? Now, this is one of the biggest challenges family lawyers are facing right now, and you might be one of the sharpest attorneys in your market with real results, real client wins, but if you're not visible online, those families never even knew you existed. They just hired someone else, and every month that goes by, that gap gets wider and wider. But the good news is there is a fix. With the right digital marketing strategy covering local SEO, targeted ads, and funnel-based content marketing, you can not only attract more inquiries, you can convert them into actual signed clients walking through your door. And here's the best part of it all. Stick around all the way to the end of the panel because we have something special lined up for you, something that could change how your firm shows up online and the kind of cases you start attracting. So you do not want to miss it, right? Now, tonight's conversation is organized around 5 key pillars that are shaping family law practice right now. 1, the biggest legal risks facing family lawyers in 2026. 2, the rise of new client profiles and modern family structures. 3, financial protection as a core pillar of family law. 4, adapting to evolving client expectations. And 5, new opportunities for growth in family law practice. Let's meet our panelists who will guide us through this discussion. First up, we have Barry Goldstein. He is the partner at Goldstein and York and the founder of DV Experts LLC. With over 43 years in domestic violence movement as an author, advocate, expert witness, and former battered women's shelter board chair, Barry helps family lawyers see the risk signals in custody cases before they become crisis. Barry, great to have you on the panel.
Happy to be here.
Great, thanks. Joining us is Jacqueline Newman. She's the managing partner of Berkman, Botker, Newman, and Sheen LLP, and one of the most recognized names in high net worth divorce and family law. She's the author of The New Rules of Divorce, published by Simon and Schutzer, and has been featured on NBC News, ABC News, The New York Times, Reuters, and CNBC. Jacqueline helps her clients and tonight all of us understand how to protect what matters most when families go through change. Jacqueline, it's great to have you on the panel.
Thanks so much for having me.
Right. Now that we met everyone on this side of the table, I do want to get a bit of a pulse check on who is in our audience tonight. So I'm going to launch a quick poll. Here we go. If you please go ahead and poll in. So the question is, right now, what is the biggest gap holding your family law practice back? Is it option one, I'm missing risk signals in custody and DV cases before they escalate? Or option two, my clients arrive with unrealistic expectations and I struggle to reset them. Option three, I'm handling more cases but attracting the wrong client mix. Or option four, my firm is invisible online to reach the clients I actually want. And right now, leading the charge is option one, missing risk signals in custody and DV cases, followed by not enough visibility online. All right, I do not have a law practice. I'm an advocate. That's great, Sherilyn. It's still great to have you here. Do let us know what are the issues that you're going through with down the line. So in lead here is missing risk signals in custody and DV cases before they even escalate. I'm going to end the poll in 3, 2, 1. Thank you everyone for joining in on the poll. Now I'm going to share the results with our panelists. So panelists, the biggest gap holding our attendees here tonight is that they're missing risk signals in custody and DV cases before they escalate. And of course, followed up by that is firm not being visible online enough to reach the clients that they actually want. Now, for those who answered the fourth option, do hang on. Make sure you hang on to the middle of the section. We have a great resource for you. And for the ones who had asked for more insight on missing risk signals, well, let's begin with the first question we got here. Barry. All right. Barry, what custody related risks are becoming harder for family lawyers to recognize before harm escalates?
I think the problem is with domestic violence custody cases, very few court professionals know the behaviors that are associated with increased risk of lethality. And I mean, I've read over 1,000 evaluations, and not one of those evaluators has done a real risk assessment, has advised the court when there are behaviors that are associated with increased risk of lethality. It's things like strangulation, forced or pressured sex, violation of court orders, assaulting a woman while pregnant, harming animals. These are things that we should be looking out for. And in most cases, we don't even talk about it. And that means that courts are making decisions about the safety of children without even knowing if they're at risk.
Now, why aren't we talking about this?
I think the problem is at the start of the DV movement, there was no research available. And the popular assumption was that domestic violence was caused by mental illness or substance abuse. And that led courts to turn to mental health professionals as if they are the experts. And even when the research came out that demonstrated that the assumptions were wrong, the courts have really been reluctant to make the kind of changes that are needed. We now have some really good research that goes to the essence of the well-being of children, and most courts are making their decisions without even thinking about this research. I'm sure we'll talk about the specific research like ACE and Saunders later, but I think that's the larger picture.
Okay, great start there, Barry. But risk of lethality seems to be the number one thing that we're really missing out on the bigger picture due to, well, as I understood, outdated research. So let's figure out what we can do about it as we go along. Thank you very much for that opener, Barry. Jacqueline, what recent client expectation has exposed gaps in how family lawyers manage complex divorce matters?
I think what I'm seeing a lot of is that there are people that, first of all, have unrealistic expectations. I mean, and that was, I saw one of the things that people didn't vote for, but you see a lot of that. And so you have a lot of people that are coming to the office with expectations of the court system being able to really address the needs that they're having. And what I'm getting, actually just listening to what Barry was saying, to the degree that the court system, and I would agree with this, is sort of defunct, is really to say it pretty blatantly. At this point, I think that there's just not enough funds that are going into the courts to really provide the support that they need. I mean, definitely agree with him as what he was saying in regards to domestic violence cases, and there's just not enough real knowledge for that. And I'm seeing the same sort of thing even in finances and all of these things. I think people are really in a position where they're just not getting the support that they want from courts, and they're unrealistic about the way that the process will unfold.
And how is that connected to recent client expectations?
Well, I think that what happens is recent client expectations are really being infiltrated by social media, by situations. Even now, AI has become a huge issue. And the fact that people are going into chat and they're coming up with all their expectations, and chat is just trying to appease them, so it's going to ultimately say the things they want to hear, and then they come to their attorneys, and then their attorneys are saying, well, that's not really what's going to happen in court. So that's a problem right there in itself.
Right. Okay. Thank you very much for that opener as well, Jacqueline. Now we do have a lot of comments here in the chat. I'm going to try to see what's going on over here. It gets pretty chaotic here. So if anyone does have a specific question, please do use the Q&A button instead of the chat. The chat is great for great chat. Part of the problem is, okay, I'm just going to read what Susan just typed in. Part of the problem is, in your state, are there adequate statutes that allow for protection of survivors and children, especially from coercive control and narcissistic abuse? Jacqueline, do you have anything to add on to that?
What was the question exactly?
No, it's not necessarily a question. It's just a thought of Susan over here mentioning that part of the problem is, in your state, are there adequate statutes that allow for protection of survivors and children, especially from coercive control and narcissistic abuse?
I would say no. I don't think that there is. I think that, again, just to piggyback on what Barry had said, I think there's a misunderstanding about what abuse looks like. I think, there's financial abuse, there's coercive control to that point. It's not always just about being physical. If anything, I think that very often a lot of abuse occurs that actually may not even come out as physical. And so I don't think the courts are really equipped to do that, which I think, again, goes back to funding and knowledge and just being overburdened.
Check.
If
Barry,
I
you have
could,
it?
in
Of
New
course, of
York,
course.
there is legislation called Kira's Law, named after Kira Franchetti, who is one of over 1,000 child victims murdered mostly by abusive fathers because the courts failed to protect the children. And Kira's Law is based on the Safe Child Act, so it's a comprehensive proposal that would really solve the problem. And what's really frustrating in New York, the state Senate passed Kira's Law unanimously, and there are a majority of the assembly are sponsors of the law. But what has happened is that the assembly speaker refused to allow it to be voted on, and the governor hasn't used her influence to get it voted on. This is the solution. One of the things that's frustrating, my new book came out recently, and one of the findings was that the failure of custody courts to protect victims of abuse has resulted in a huge increase in domestic violence homicide. Kira's Law would stop that, would save the state a huge amount of money, particularly in healthcare costs, but they're not doing what they need to do to protect children. In many other states, they have passed some really good laws, but they're partial laws. The legislators have been unwilling to do the kind of comprehensive legislation that would deal with all the problems so that we could finally protect children.
And there lies the tricky part. If there is any way to save on healthcare costs, all the powers in the world seems to be working against that. That's a whole nother discussion in itself. Thanks, Barry, for that wonderful insight. Yeah. Now, which patterns in domestic violence and child custody cases should lawyers treat as urgent in 2026? Barry, this question's for you.
As I mentioned before, there are studies that are really the best tools for handling domestic violence custody cases. The first is the ACE research, ACE, it stands for Adverse Childhood Experiences. This is peer-reviewed medical research, comes from the CDC, so highly credible. Fundamentally, what ACE tells us is that children exposed to domestic violence, child abuse, other kinds of trauma will live shorter and less healthy lives. So fundamentally, when courts don't use ACE, they're minimizing the harm from domestic violence and child abuse. It goes to the essence of the well-being of children. It is absolutely absurd that courts are not using ACE. ACE came out in 1998. We could have saved thousands and thousands of children, and the courts are still not using it. And I have yet to hear any of the judges explain, why don't you use the best research? The other study is the Saunders study, which looked at the domestic violence knowledge of judges, lawyers, and particularly evaluators. And this, again, is peer-reviewed research. This comes from the National Institute of Justice in the U.S. Justice Department. So again, highly credible. And what they found is that most court professionals do not have the specific domestic violence knowledge that's needed. The recommendation is to use a multidisciplinary approach that would include mental health professionals who are expert in psychology and mental illness. It would include lawyers who are expert in the law and analytical thinking, but it requires domestic violence experts because DV is a very specialized area of knowledge and the courts aren't using it. And Saunders tells us, how do we screen for domestic violence? Because one of the big problems is that most domestic violence is committed in private for obvious reasons. And a lot of untrained court professionals treat that as, well, it's he said, she said, there's no independent witness, so we can't tell. But DV experts know what to look for to have a little bit more information that makes it more likely that what he said or what she said is true, and the courts aren't doing that. So without Saunders, we're disbelieving true reports of abuse. And very often what happens is the mother continues to try to protect her children. That's what mothers do. It's what they're supposed to do. But courts get angry at them and often retaliate against the mother trying to protect the children after the court failed to recognize true reports of abuse. It makes absolutely no sense for the courts to try to handle the most dangerous cases without the best tools like ACE and Saunders.
Check. Oof, there's a lot to unpack there, but definitely court professionals just not having that adequate understanding to really deal with the DV cases. So make sure you're trying to get those DV experts involved in it. Yeah, I mean, 1998, that's the latest updated research that we can have a chance of bringing justice
Don,
to
can I
these
actually
DV
ask
cases.
Barry a question? Is that going off script? Is that okay?
Yeah,
I
go
want
ahead.
to kind
Go
of
ahead.
follow up on this. So I'm kind of curious because what you're saying, obviously, makes total sense. And, as somebody who also litigates and is involved in custody cases, you're right. I will tell you, DV experts don't even come up as something that is, brought in as a general thing. I mean, what we'll have forensics, we'll have all these people, but they're not experts. And so when you've spoken to judges and you've said no one's given you an adequate answer, what even answer do they give as to why they would not apply these specialties that obviously have been proven?
Well, I guess I can respond to that. I mean, most of the time they don't talk about it. When we go to court and we want to testify about ACE and Saunders, they will usually listen to us and it can make a difference. We've saved many children, but most cases don't have a DV expert, so the courts never hear about ACE and Saunders. I mean, I would share with you, and we're back to the state of New York. I had a case near Albany where the judge had just had a training in ACE. And when I came to testify, he was delighted to have an ACE expert in the court. And whenever the attorney for the abuser objected to something I said, he would quote what I just testified to in denying the objection. And the outcome was what it should have been: custody for the safe mother, supervised visits for the dangerous abuser. The father was very upset at that. He appealed it all the way to the highest court and he lost because the research and the evidence supported protecting the children. But most cases don't have that. And Jacqueline, one of the things that interests me is that I'm sure we both know many attorneys handling other types of cases, and they will spend hours upon hours to learn technical material so they can cross-examine experts, etc. And domestic violence, which they're going to encounter cases with over and over again, they don't do that. They don't think of domestic violence as the specialized area of knowledge that it is.
Yeah, I would agree. I think that to the point that you made earlier, I think there is an element of people feeling it's a he said, she said. And because it's hard to prove what's going on behind closed doors at times, unless there are actual bruises, I think judges don't want to hear it in the same capacity. And so it's a hard claim. And unfortunately, there are people that make claims that may not be true. And so it's kind of a typical thing in my world where you'll have somebody who will make a motion for exclusive occupancy and they'll go into the family court to do it just as a pure way to get somebody out of the house. And then they'll, consolidate up to the Supreme Court, and then the person's out. And even if there wasn't, necessarily violence, that's, it happens very quickly, and courts in that situation don't want to take a chance. But then there's a custody. I mean, there's so many ramifications to it. So I don't feel like that happens. And even, I'm thinking right now, like I have a case in my office, and it's interesting, like a DV expert, I don't feel like anyone's ever even talked about bringing in a DV expert. Like it's an interesting concept, and you're 100% right that why it's not looked at as a specialty in that manner, I don't have an answer for.
Wow, that's what we're looking for. We're looking to get people thinking in the right way to get those answers. So fantastic discussion there. Loved it. Jacqueline, thank you very much for the question. Really appreciate that. Now, Jacqueline, a bit on a different side of things. When financial complexity arises, what should lawyers prioritize between speed, protection, and client control?
I think when it comes down to it, honestly, it's really sort of all of it. I mean, client control to some degree, depending on what they're doing. But I think that really speed is not necessarily the factor. I think it's just very important to be accurate and to not make presumptions. And, different than, what we're talking about in regards to domestic violence, there are documents. I mean, there's no he said, she said a lot. There are actual documents and financial documents. So I think accuracy is important. And I was saying that I do think there is not as much he said, she said. There can be ambiguity, obviously, and there could be people's interpretation, but financials are much more clean cut, I would say, than any kind of, there's a much more of an objectivity to it than there would be to a domestic abuse situation, where some people may deem that to be subjective, some may not. But so I think that really it comes down to definitely being careful in what you're doing. I mean, speed can play a role to the degree that if you have somebody who might be wasting assets or things like that, but there are ways to address that. So I think really what it comes down to is accuracy is the number one thing that you want to be looking for.
How do you address speed while being accurate? Of course.
Speed and being accurate. I mean, I think that there are ways to do it, but as I said, I don't see speed as the number one factor in this. I think that we're really looking at, there's AI now, which is definitely speeding things up. So that is one of the things that we've been using in regards to discovery and things like that. So there are ways to internally move faster than what I think we've been able to do in the past, but I can't stress that enough about accuracy. I would take accuracy over speed.
Absolutely. Barry, you wanted to add something there.
To put something in context, economic abuse is a really important part of domestic violence. About 99% of DV includes economic abuse. And courts are used to parties arguing over money, and they miss the important difference in a custody case. DV is about control, including financial control. So in most DV custody cases, the money is on the side of abusers. And what that means is that they have this unfair advantage. And when an abuser is taking money from the victim, not paying support, stealing money, hiding money, wasting all sorts of money on unnecessary litigation, they're not just hurting the mother, they're hurting the child. An abuser who claims to be acting out of love for the child, when they're taking money that could otherwise be used for the child, that demonstrates that they're not acting out of love for the child. They're acting out of their desire to have power and control. And the problem is the courts aren't adjusting. And there are two things the courts need to do. Judge Mike Brigner wrote a chapter in my first book with Dr. Motrice Hanna, talking about that judges have the power and the authority to level the playing field, and that would be to have the wealthier party pay some of the legal and other costs for the less wealthy party, so that the court can get both sides fairly. And what Judge Brigner was saying is that courts aren't using that power as often as they should, as effectively as they should, but that needs to be done. The other thing is there's a really important book in the DV field called The Batter as Parent, Lundy Bancroft and Jay Silverman. And one of their recommendations is that any expenses made necessary by someone's abuse should be paid for by the abuser. And what's really important, if courts did that, you would have a fairer case where both sides can, provide the information, to support their case. Very often, because one side has all the money, very often the poor side loses representation. The court doesn't even get the information it needs to make a good
Right.
decision for children.
Wow. There's a lot of yeah, I mean, this just goes back to the second question which Jacqueline answered. Just a lot of these issues do come about because courts are inadequate, and that's unfortunate. It's truly unfortunate. Yeah, we have a couple of questions from our registrants that share the same sentiment, which we will get into in a little bit. Dana, thank you very much for that question. So now, Barry, what criteria should guide lawyers when evaluating abuse allegations within a custody strategy? What are the top three?
Well, fundamentally, when children are exposed to domestic violence and child abuse, they're going to lose years from their life.
That's
And
right.
most of the harm from domestic violence and child abuse is not any immediate physical injury. It's living with the fear and stress that is going to ruin the children's life. And again, stress is what we should focus on, and yet courts almost never do. Very often, the courts will impose outcomes that add to the children's stress when the research says it's critical to reduce the children's stress. And that stress causes cancer and heart disease. It causes mental health problems, the many different kinds of problems. In our new book, we interviewed people from the Cancer Society and the Heart Association, and they agree with us. They have the same research. They understand that when we tolerate domestic violence and child abuse, we are increasing cancer and heart disease. And one of the reasons I'm excited about that finding is that when we go to court and testify, the Heart Association says this, the Cancer Society says this, courts are more willing to listen. Those are organizations that are highly respected, very credible, and it's really helpful. And one of the things that's interesting, we may talk about alienation later, but the outcome that the biased alienation theories like is exactly the opposite of what the American Heart Association recommends. And I think that's a pretty strong argument that courts have never heard before. And so I'm excited that we have some new information from our book and to share it in audiences like this and with the courts, because it's really persuasive. And most of all, it goes to the essence of the well-being of children, which is what courts are supposed to be focused on.
Check. So absolutely. I think what I'm understanding here is, stress being something much more emotional, it's difficult to really create a tangible grasp on. Whereas when you have these physical manifestations in form of increased risk of cancer and heart diseases backed by authoritative bodies, it's much more easier for us to make the case. So some things to really think about when it comes to evaluating your own DV cases. So, Jacqueline, where should family lawyers draw the line between personalized service and unsustainable client accommodation?
So I guess that's really a boundary question.
That is.
And it's challenging. I mean, these are people coming to you in incredibly difficult times in your lives. You're getting to know them as people. I will admit, I am probably not the greatest person to answer that question. My boundaries are very, 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 very weak to the degree that I do give my cell phone out. Clients know they can call me on the weekends. I am very accessible because I think that you do establish these relationships. That said, to your point, I think that you have to be self-protective. Obviously, doing this is a very stressful thing. And people that are divorce attorneys and working in this field as a whole have their own families and their own levels of stress. And so I think it's important to have that type of balance. And clients can take advantage of you at times, and that's something you have to be aware of and have certain clear boundaries when it comes to that. So for me, I think it is important to be able to be there for your client and be supportive and recognize the point that they're at and still be self-protective. Because if you are in a situation where you are ultimately getting worn down, and then you're not going to be in the best place to really help your client, which is the goal.
Seemingly, you seem to be in a great position just telling by your smile. How are you managing that? Give us some tips.
So I've been doing this for a long time. I will say, I actually love what I do. And I think that that's part of it. I think matrimonial law as a whole, I tell people all the time, like, try it when you're in law school, because if you don't like it, you're not going to do well at it. Like, it's one of those things, you kind of love it or you hate it. I happen to love it. I think it's an honor to be in these people's lives at this time and really watch them strengthen. Some of my, most rewarding moments are when I have a client that comes to me and can barely finish a sentence, that this person is so incredibly upset. They think their whole lives are, completely blowing up. And then they walk out so strong. And they walk out really recognizing that maybe they were in an abusive relationship in whatever context, and now they're open to being in a healthy one. So to watch that strength, that inner strength build, and also to be evidencing that for your children, which I think is so incredibly important. I say a lot when we have clients that are in dysfunctional relationships and marriages, I say, you're role modeling for your children. Like, just so you know, and I say a lot, how would you feel if your daughter or son came to you and described the same marriage you're in and said that they were in it? Would you tell them to stay? And that's in essence what you're doing, because if you allow them to watch these kind of dysfunctional relationships, you're setting your cycle. And so for me, it's very important. And I feel really honored that I'm in a position to kind of help people stop those cycles. So I do love what I do. People ask a lot, does it impact your marriage? I joke all the time that it makes the fact that my husband doesn't put his dishes in the dishwasher, like a little less annoying, just because I know how much worse it could be, even though the dishwasher is obviously right in arm's length and he could just easily do it. But I do think it gives you a little context of how things could be. Yeah, I feel really lucky. I love my job.
Amazing. It seems that you found meaning in what you do, and that really helps you with that. But of course, for everyone else, find meaning, definitely, but also have that clear boundaries and find your own self-protection that'll allow you to thrive with that meaning in your own capacity. Now, with that being said, I do want to share something real quickly here. Now, we have spent the last 30 minutes talking about the risks that are reshaping family law practice. And here is an uncomfortable truth underneath all of it. None of that strategy matters if the right client never finds you in the first place. Right now, while we're talking, a family in your law market is searching for a divorce attorney near me. Another is searching for a child custody lawyer, and another for how do I protect my assets in a divorce. Yes, they do search things like that in long tail keywords. So did your firm show up? That's the main question. Did your firm show up? Because if it didn't, then they just hired someone else. And this is the exact gap that Equa Marketing closes. For over 18 years, they have helped more than 900 practices across legal and healthcare become the first name their ideal clients find and trust. And tonight, as a token of appreciation for registering and being here with us, to every person in this session, Equa is offering a complimentary 45-minute marketing strategy meeting, a focused session where their team researches your firm's online visibility, SEO positions, and review profile before you even show up. Now, you will walk away knowing exactly where you're losing clients and also, most importantly, what to fix first. This session is normally valued at $900, but it's yours tonight at no cost. Scan the QR code on your screen right now, or else you can click the link in the chat below. It'll take less than a minute to book, zero commitment. You're just reserving your spot. And look, I know what you may be thinking. Is this worth my time? Here's how I'd frame it. Really, the only thing you're risking is an hour. There's no obligation whatsoever. But the only thing you're risking by not doing it is another year of competitors showing up when your clients are searching, and you don't. So I'll leave that with you. So go ahead and grab that link, book the session with Equa. It'll be time well spent. Right. Now we're getting into one of my favorite segments of this session, your Q&A. All right. And we got 5 questions lined up. Fantastic. We'll get into these first, and then we also have some questions from our registrants as well. We will try our best to answer as much as possible, covering the breadth of your concerns. Now, first of all, we got Dina, who has said, I've been a DV advocate coach for over 10 years. I bring my legislative and finance background to my project, which provides legal, financial, and communication strategies to survivors struggling through family court. I think it would be beneficial for family law attorneys to partner with DV experts like me who can help handle intakes and pinpoint the specific elements of DV in a worst case. DV experts can distill 2 hours of a client's worst case scenario fears into a dozen bullet point questions for the attorneys and a rough frame for discovery. How do attorneys feel about a partnership like this? Okay, I only read the question at the very end. How do attorneys feel about partnerships like this? I want to ask Jacqueline this. You know what?
I mean, I'll be honest, it has not been something that has really crossed our paths before this. Personally, I will say I don't work with many cases. My firm does. I personally probably do not have as many overt DV cases. That said, after this, I'm happy to consider that. And it definitely, if we had a case that really had evidencing of DV and it was a factor that a court is considering, I think an expert would be an excellent idea.
Amazing. And I think I know where Barry stands on that argument.
Well, the most common question that we get as DV experts, and the same is true for DV advocates, is where can I find a good attorney for DV? Because most attorneys do not have the expertise. And even worse than that, because that we can overcome if they're willing to listen to a DV expert. But a lot of them aren't. And one of the problems in the court system is that they very frequently retaliate against protective mothers. And as a result of that, many attorneys are afraid to present evidence of abuse, especially sexual abuse of children. And what that means is the court doesn't even have the opportunity to do what they need to protect the children. The courts aren't getting the information they need. And so we need attorneys who are willing to advocate for protective mothers. And we constantly are being asked by our clients, do you know an attorney in this area or that area that we can get? If we could get attorneys who would like to work with us, you'd get more business, but you'd also help your clients more. And, I'd love to see more of that. We're starting to see a few attorneys that we've worked with regularly come back to us. And again, we'd like more. Protective mothers need effective attorneys.
So Barry, I can respond to that a little bit. Part of the problem is that courts will say to you, sometimes directly and sometimes indirectly, that should you bring this case and make sexual abuse claims and you lose, you're going to lose custody. And so the fear becomes for these mothers is that who knows what a court's going to do? Who knows what a court's going to believe? Who knows what a child is going to say? And so, and I will say, as I say this out loud, I think to myself, more of a reason to have a DV expert. But at the end of the day, that is incredibly scary to a mother who knows this person's abusive and says, okay, so if I take a chance in a court system, which, to your point, isn't educated, isn't in a situation where they're willing to give the time, think about it, like it would be terrifying that if you ultimately go through the court process and it does not do what it's supposed to do, and now not only are you losing your child to an abuser, like that is the worst that can ever happen. And so it's very hard. It's just a really big risk. And in my experience, and again, I have personally not had a ton of experience, but as I said, my firm has. But I know we had a case once where a mother, and I was a little on the peripheral of this case, but I will say I remember the mother had concerns, but she was scared to do it because the message is pretty clear that you better have an iron shut case. And these are subjective views that people have, and so iron shut just doesn't really exist.
If I could just give you some facts, because you're absolutely right. The research is this: mothers involved in contested custody make deliberate false reports less than 2% of the time. And that finding is particularly about child sexual abuse. But the Meyer study, which is the main outcome study, found that when a mother raises concerns about possible child sexual abuse and the father counters with the alienation tactic, custody courts disbelieve 98% of the cases, which means that the courts are getting a very high percentage of these cases wrong. And of all the ACEs, child sexual abuse is the most harmful. So if the answer is we can't raise child sexual abuse because the court doesn't know how to handle it, it means we're going to ruin a lot of children's lives. The ACE study found that in the United States, 1/4 of our children will be sexually abused by the time they're 18. That's outrageous. And it's because not just the custody courts, but many systems within our society are failing our children. And the solution ultimately has to be for the courts and for the other agencies to do a better job, not that we're going to let children suffer more abuse. We've got to change that.
Yeah, I mean, I couldn't agree with you more. And you brought up the alienation. You're right. I mean, people throw around the term alienation as a defense constantly. I mean, that is, if a child does not like to be with their parents for whatever reason, they claim they're being alienated. There's no look inside. There's no, being a little bit responsible and recognizing that, whatever role you played may be infiltrating why this child is reacting the way the child is reacting. But
No.
yeah, I mean, I wish I had a good answer, and I wish I could take you and bring you to all the courts and say to all the courts, like, you need to listen, because it is incredibly scary. I mean, those stats you just said actually made my stomach hurt. Like, that is just awful.
Now, I also have one other question, which I had selected because a lot of the registrant questions were kind of on a similar sentiment, and that's by Sherilyn, who's also here as an advocate. Now, what are the clearest signs that a parent is weaponizing systems, police reports, GALs, therapists, school complaints, repeated motions, and how should a lawyer respond when that pattern is the actual strategy? Barry?
Well, the problem is that all of the different court professionals, judges, lawyers, evaluators, parent coordinators, GALs, with very rare exceptions, do not have the domestic violence expertise that they need. That's part of the findings in Saunders, but it hasn't caused these professionals to try to get the training that they need. And too often they're not even willing to listen when there is somebody with that training. As we've said earlier, DV is a specialized area of knowledge, and the other professionals need to recognize it. Saunders recommends a multidisciplinary approach. If we could get into that, if the other professionals would recognize that just as they have specialized training in their field, the same is true about DV experts. If we could pool our knowledge and expertise, we could better protect children, which is presumably what we all want to do.
Okay. Jacqueline, do you have anything to add on to that?
I just agree. And I mean, I wish I could come up with an answer of any type. I mean, I see what happens, and in a non-DV fully specific situation, but just, the hostility that exists between parents and how it infiltrates their children. I mean, when you speak about the issues about heart attacks and stuff, I've spoken about that, not specifically with DV, but just abusive situations and negative situations. And I have read a study about how that impacts your life later on, just the stress of living in these dynamics. And so it's an interesting thing. And you do have to get somebody who's going to pay attention. And unfortunately, again, it goes back a little bit also to the fact that these courts are completely overburdened. These judges are overburdened. You walk into a courtroom, you have about 6 minutes tops to present your case until the next one's coming on, and or just piles high. And, I know a lot of really good judges who I think would love to be able to do a better job, and they just don't have the time to do it. And that's really where I think one of the major problems comes in. In my ideal world, I'd like to think if people had more time and there were more resources, we may be in a situation that this is not happening to the degree that it is.
There we go. Okay, just to wrap things out over here, Barry, Haley has asked, where can we find the study on the 2%?
That's the Bala study. You might remember that the last time I appeared, Nicholas Bala was the other guest. He was the lead author of that study. Should be able to find it online. It's certainly cited repeatedly in our book. It's really basic. And, there are other studies that have similar concerns. The problem is that the alienation theories have sought to spread a myth that women frequently make false reports, and that's just wrong. But if you look up the Nicholas Bala study, you should be able to find that information. And I should also mention, if you look at the Saunders study cites the Bala study in many places.
Right. Now, we're here at our final round of questions. And my next question to you is, Barry, what intake workflow helps lawyers really identify coercive control before custody positions are shaped?
So it's interesting. Somebody asked me about a new law in Utah that is designed to include coercive control. And coercive control is part of domestic violence. One of the things we like to tell the courts is that most domestic violence is neither physical nor illegal. It's all these various coercive and controlling tactics. And those tactics cause the stress that the ACE study talks about that ruin children's lives. I think at the start of the DV movement, courts were only concerned about physical abuse, and that turned out to be a mistake. And yet, even today, very often, you'll hear court professionals talk about, well, there was no physical abuse, or it was relatively, quote, minor, and so they don't feel the need to protect children. And in not protecting the children, they are ruining their lives. And that's what needs to be changed, that the tactics that are called coercive control are more than enough to ruin a child's life. So we should pay attention to it.
And bringing that up in the discussion in a way that is productive is the task at hand. There was a registering question that I know we're going to be tight for time. So let me see what we can do. Jacqueline, right. Yeah, this question is great. What signs tell you a family law firm is truly serving complex clients better, especially in high asset or high conflict matters?
Kinds of people. I mean, generally, if you're dealing with people that are dealing in the high net worth space, dealing with people with complex asset structures, business structures, things like that, if you're dealing with people that run hedge funds, that are dealing with entertainers, like people that basically are dealing with kind of the type of cases that are not necessarily straightforward W-2 employees, odds are they're going to be in a situation where they'll be able to evaluate complex assets and different types of income streams.
Okay, I'm just going to keep things moving here because of the tight time schedule. Otherwise, I would have had so many follow-up questions right there. But Barry, how should legal teams coordinate with advocates, clinicians, or experts without weakening case strategy? This is the key question.
Well, I think context is important, the research is important, and we need to put it together. We should all be allies in trying to protect children. And I think one of the things, we haven't really touched on tonight is that the courts developed a lot of mistaken practices, a lot of mistaken assumptions, and they never changed that when the research came out that they were wrong. One of the things I love about Kira's law and about the Save Child Act is it specifically says, stop doing the things that are harming children. Because a lot of times, no judge wants to hurt children, but they're used to doing things, they're comfortable doing things that are harmful. And so we need the professionals to be open to doing something differently, to take a look at the new research, stop doing what is harming children, and start using the research to protect children. That seems obvious, but it's not happening in most of the courtrooms yet. Let's emphasize yet.
And what a great point to really segue into the final key takeaway. Now, I do want to ask both of our panelists for the golden nugget of our conversation that you would want our attorneys listening in on the call to really take away and implement right away, starting tomorrow, for a better world with less DV. Jacqueline, how about you? What's the key takeaway here?
I think the key takeaway for me, I'll say specifically, is really learning about the role that DV experts are playing. As I said, it was not something that really crossed my path, and I've been doing this for over 25 years, and it's not something that you hear about very often. So it is a tool that I'm going to take back to my firm, absolutely, and hear about it. And talk about it with everybody. So for me, it's really that, and just recognizing how important it is to be educated, whether it be on finances going through divorce, or whether it be and being able to witness and be aware of whatever DV that's going on in your home to your child, et cetera, to really be open and to see what's going on and protect your kids.
Check. That's great takeaway. And we're so happy that even at least one person has a new perspective on the issue. Barry, how about yourself? What's the key takeaway here?
If I'm not being too crass, I would really like to mention my book,
There we go.
Preventing DV and Child Abuse, because what we found is we have this new research, and the research, in one way, it's sad because it means that what we're doing now is so much more harmful than we can imagine. But it's also exciting because given the financial and other costs of tolerating domestic violence and child abuse, that could be a huge incentive to change everything. We spent a lot of time on the anti-smoking crusade because what they did there, which saved millions of lives and trillions of dollars, we can do by reducing domestic violence and child abuse. And, so it's a huge incentive. And we can imagine the Cancer Society and the Heart Association taking a lead for the same reason that they did with preventing smoking. And so if we can get the right leadership, we could do something that is hugely different and could really change our world in some wonderful ways. I think most people don't understand that everybody is spending, in the United States, everybody is spending $11,000 a year to tolerate domestic violence. And if we can recover even a chunk of that, it would change our country in the most wonderful ways, in addition to making the children in our courts safe.
Absolutely. Absolutely. Thank you so much, Barry, for that wonderful reminder. And where can the people find your book, by the way?
It's published by Civic Research Institute, and the only place to buy it is from the website, but it is available now, as you can see. So if you go to the website, Civic Research Institute, look for Preventing Domestic Violence and Child Abuse, and I hope you'll take a look at it. I would love people to share it with judges and lawyers and other professionals, and because I think if they understand the harm that the present practices are doing, our love for our children will cause us to make the changes that we need.
Check. Wonderful takeaways here. Appreciate your insight there, Barry, as well. And now, beginning the wrap-up sequence here. So before we end, I do want to remind one last time, make the best use of EQUA's complementary marketing strategy meeting for the clients in your area that are searching for the offers you deliver. Make sure your firm is the one that they find and choose. Link to book is in the chat box. One last time, go ahead and make that commitment. And of course, that being said, this has been genuinely a powerful, powerful hour. If you carry one thing out tonight, let it be this: the biggest risks in family law in 2026 are the ones you do not see coming. And the best defense is the right systems, the right intake, and of course, the right visibility. And as you exit out of this session, quick feedback survey will pop up. Please do take 30 seconds to fill that out. It'll help us keep these panels high value. And of course, Barry, Jacqueline, incredible work tonight. Do stay on the line for a quick debrief. Attendees, thank you so much for your time, your questions, and everything you do for the families who trust you with their most difficult moments. That being said, I'm Don Adeesha, and we will see you at the next Dominate Law Expert panel. Good night, everyone.